Good morning. My name is David Hayes. I'm the Executive Director of the State Energy and Environmental Impact Center here at NYU Law School. It's my pleasure to welcome you here today, both those of you who are here in person and those of you who are watching on our live webcast. As you know, major health and environmental controversies burst on the national scene with some regularity, often raising challenging legal and policy issues around liability, restoration, and restitution. These issues are often tough for single courts or for our legal system generally to handle. And yet, precisely because these health matters like tobacco and vaccines, or environmental dangers or disasters like toxic sites or the Gulf oil spill can affect so many people in so many ways, in so many jurisdictions, and because the societal challenges they represent must be addressed and in some fashion solved, we somehow wrestle them to the ground, sometimes with efficient, fair, and effective results, sometimes less so. At the State Impact Center, as part of our charge of assisting state attorneys general on clean energy, climate change, and environmental issues, we have launched a health and environmental settlements project. Our goal for the project is to help lawyers, legislators, and judges better access lessons learned from past legislative and judicial resolutions of particularly challenging and important health and environmental issues of national importance. Toward that end, we're looking to dissect and evaluate key elements from a handful of major legislative and judicial settlements. We want to spot, in particular, structures and mechanisms that have been used effectively or not to determine personal, corporate, and societal liability, to award compensation, including for future as yet unknown injuries, and to redress harms, restore resources, or otherwise provide appropriate restitution, including for as yet unknown health or environmental insults. Today we have a spectacular group of experts who have intimate knowledge about 4 major settlements that offer unique learnings on some or all of these issues. By putting these matters side by side in today's workshop, we will begin the process of extracting insights that will help lawyers tackle future health and environmental liability and restitution challenges that are sure to come. A quick word on what's next for our settlements project. After today, we will commission written analyses of the 4 major matters that we will be discussing, and likely additional settlements that have noteworthy features that may include, for example, the National Childhood Vaccine Injury Act, asbestos, and possibly others. We will aim to put these together in a useful compendium along with some overarching analysis that will be published a year from now. I want to thank our keynote speakers, Ken Feinberg and Dr. Cheryl Hilton in particular, and our spectacular experts whose outstanding bios are in your materials for agreeing to participate in today's event. You're providing a true public service by contributing your knowledge and insights to this endeavor. But now I want to turn over the mic to my friend and colleague, Professor Ricky Revesz, Director of the Institute for Policy Integrity here at NYU, the former Dean of NYU, to introduce our keynoter, Ken Feinberg.
Thank you, David. One of the great things that happened at NYU Law School a year and a half ago is when David and the State Impact Center joined us. And it's been wonderful to have David as a colleague here at the law school and to observe the really spectacular and very important work that the State Impact Center is doing, supporting, encouraging, and adding capacity to the work of state attorneys general who are doing such critically important work in the clean energy and environment areas. So I said this was a great thing that happened a year and a half ago. A great thing that happened a longer time ago was when Ken Feinberg came to the law school as a student, because it was a few years ago. I won't tell you how many. But Ken is one of the law school's all-time most distinguished alumni. And to actually focus on what Ken has accomplished in the area of this conference is extraordinary. Ken, among other things, I mean, it would take forever to list all of the incredible assignments that Ken has discharged with enormous grace and efficiency and competence and integrity. But he was the special master on the U.S. government September 11 Victim Compensation Fund. He was special master for the TARP executive compensation. He was the government-appointed administrator of the BP Deepwater Horizon Disaster Victim Compensation Fund. He was appointed by the Commonwealth of Massachusetts to administer the One Fund, the Victim Assistance Fund established in the wake of the 2013 Boston Marathon bombing. He was retained by GM to assist in the recall response and by Volkswagen to oversee their U.S. compensation of diesel owners affected by the emissions scandal. He was the settlement master in the Agent Orange products liability litigation, the asbestos personal injury litigation and DES cases. You know, if the FTC could investigate monopolization of great special master assignments, they would definitely go after Ken. They would have done this a long time ago. I mean, it's truly, truly extraordinary. I mean, you know, it's actually hard to imagine how in the sort of very competitive world we live in, one person can dominate a really important field of law in the way that Ken has dominated this field. He has also done some other, maybe less well-known but super interesting things. He was one of 3 arbitrators who determined the fair market value of the Zapruder film on the Kennedy assassination. Was one of 2 arbitrators who determined the allocation of legal fees in the Holocaust slave labor litigation. And early in his career, Ken spent considerable time as chief of staff for U.S. Senator Ted Kennedy, was a prosecutor in the U.S. Attorney's Office, was a founding partner of the Case Scholer D.C. office, and eventually founded his own firm, the Feinberg Group. During my years as dean, I had the chance to get to know Ken. He's been a wonderful friend and mentor, and it's sort of really hard to imagine how a law school, any law school, could have a more successful and distinguished and admirable alumnus. So it gives me enormous pleasure to now get to introduce Ken, who will give us a keynote talk. Thanks so much, Ken.
That just took 17 of my 20 minutes. I thank the dean, former Dean Revesz. I thank David for the invitation. And I must say, when you're going to give a keynote, it's always better, I've learned over the years, to give the keynote up front at the beginning rather than at the end of the day to sort of summarize. Because if you do it at the end of the day and you summarize in the view of a lot of the people in the audience incorrectly. And then people start to complain. Whereas if you do it early on and sort of set out a blueprint, that, you're sort of safe. You're sort of safe. And what I want to do in literally 20 minutes, David and Ricky are tough taskmasters on this. I just want to lay out some principles that I guarantee will occupy your attention during the rest of the agenda today. First of all, whoever thought of the timing of this conference is a genius. In the last few days, just picking up the New York Times, PG&E, the utility in California with the fires, files for bankruptcy. What are we going to do? How are we going to settle all these claims? Chrysler. We just settled the Chrysler emissions case in the last month in the U.S. District Court in San Francisco, Judge Chen. Emissions, 125,000 trucks, Chrysler vehicles, settled through a very creative process. 9/11, they're running out of money. I read in the newspaper there's a droga bill right here in New York for first responders. They've cut back on how much they can give each settled responder because Congress didn't appropriate enough money. And Congress didn't appropriate enough money because if you look at that 9/11 fund and you see the presumptions they've created in the area of health, if you see the presumptions they've created in terms of who's eligible, not just first responders, citizens, people that live near the dump where they dump the guck. I mean, you can see how Congress didn't anticipate the number of claims that would require a reduction in the overall distribution of funds. Everything that's going on in the newspaper today, somebody thought about a conference today. A lot of sense in bringing forth some of these issues. Now, I can't stay for the day, but I must say John Cruden's here somewhere, and David Nachman's supposed to be here at some point from the New York AG's office. They know everything. If I was here all day, John Cruden and David Nachman know exactly what I'm talking about when I lay out this menu of items, and they're certainly going to be here, and they understand these issues perhaps better than anybody. Now, I want to focus on just two subjects. First, and it's just a menu of issues that you're going to confront today when you talk about the settlement of these large, huge environmental health impact cases. Here's what I've learned over the last 35 years about settling and resolving these huge cases. First is the structure that you use to promote the settlement. What do I mean by structure? The skeleton, not the substance. Is the settlement initiative court-sponsored? Like 9/11, like Agent Orange was, Judge Weinstein, or Volkswagen was, Judge Breyer in California. Is it court-sponsored, or is it private? The BP Deepwater Horizon oil spill, the Boston Marathon bombings, the GM ignition switch program. I mean, skeleton issue number one, court overlay or something private off to the side, extrajudicial. I've done them both, different rules. Two, is the insurance industry involved? Never in my cases, thank goodness. No, they have some very legitimate gripes, don't get me wrong. But if you look at what you're focusing on today, for the most part, Volkswagen, BP, 9/11, no insurers anywhere at the table can get it done. We'll worry about contribution and subrogation later, not on your watch. My goal in these big cases, get rid of the individual plaintiff claims. And I shudder to think about the delays and the inefficiencies if the insurance industry is at the table. It's an altogether different ballgame. I've never had to worry about that. Three, is the government involved? Now ask John Cruden and David Nachman about this. Volkswagen and Chrysler got done because the government was at the table and the government pushed towards settlement. 9/11 was a government-funded program. You'll never see that again. That was taxpayer money. So if the government is at the table, that's an additional interest group, that's an additional issue you've got to think about, but having the government there is not necessarily a good or a bad thing. It's just that you have to factor in different leverage points, different settlement considerations if the government is involved in the settlement negotiations, either directly like in Volkswagen or indirectly like in Volkswagen with David Nachman and the state AGs. Federal government directly involved, EPA and the Department of Justice, and in Chrysler, in Volkswagen, FTC involved, and in Volkswagen, in Chrysler, indirectly, David Nachman and the state AGs, government. Next structural issue, are you going to aggregate the claims? And how are you going to do that? I mean, if you're talking about a global settlement in these complex areas, are we looking at upfront as part of the skeleton an aggregation so that all the claims are being settled? Now, whether that's a Rule 23 class, an MDL, whether it's a local or regional consolidation of claims, or whether, I must say, no, we don't want to aggregate the claims. It's not feasible, and we want to set up some mechanism to resolve them one by one. And do you want to aggregate claims or resolve them one by one outside of the judicial system? That's BP. we set up a separate independent claims facility. That's 9/11, the Victim Compensation Fund. There's no aggregation of claims, but there's a facility available voluntarily for any individual to exit the court system, go into that separate facility, and resolve the claim. And that's what we did. In BP, we resolved 92% of the individual claims in 16 months and paid out $6.5 billion. In 9/11, by statute, in 33 months, we resolved 97% of the individual claims and paid out $7.1 billion in taxpayer money. So, as a skeletal matter, aggregation, government, insurers, court-sponsored, private facility, these are the issues that you've got to consider all day today in trying to set out some sort of principles or groundwork for future consideration. Also, I must say, it's a skeletal issue, but it's also substantive. What do you do in these cases involving latent claims? What do you do when you're settling claims and you've set up some sort of facility? And one of the arguments against what you're doing is, well, what are we going to do about future manifestations arising out of current exposures? That's not really traumatic death. Those are illness claims, like in BP, whether they're physical injury or business interruption claims. In BP, the oyster harvesters and the shrimpers said to me, the trouble with taking your money now is we don't know about the future. Answer, let's get creative. Well, one option I'll give you is settle your damage now, and you can come back later if there's future damage that you can show. So let's not, in a sense, it's not global peace because I'm inviting the latent victim to come back later on when there's a manifestation. But we came up with even a better idea in BP. Your alternative, if you don't want to do that, we've got our own experts who say that the shrimp and the oyster harvesting will come back to normal in 3 or 4 years. That's what they project. We'll pay you 3 or 4 years damage right now if you'll sign the release. If you're willing to take the risk, we will give you your expert opinion corroborated money now, and that's it. You bear the risk if it takes 5 or 6 or 7 years. Well, everybody took the money, of course. Of course. Of course they took the money now. You mean you'll give me 3 or 4 years damage now, a check that won't bounce, but I can't come back later. That's right, it's your choice. Where do I sign? Of course. Anybody surprised about that? So we gave people, it's creativity, you see. Latent claims can be resolved today. There are ways to do that. You just have to think through the best way to help all sides secure global settlement now. 2 other skeletal issues. What's the timing? What's the timing? How long do you want or have to try and forge a settlement? Now, in 9/11, this Congress told me 33 months. In BP, in 16 months, we were largely done, and then the lawyers took over, much to my disappointment and to BP's regret, but that was 16 months. In the GM ignition switch settlements involving that ignition switch, that if the key hit the ignition switch, the switch was defective, it would shut off the car. Young drivers particularly would crash cars into trees, etc. That lasted about a year. We paid out $600 million, GM money. So you have to have up front in your settlement menu the timing. These programs can't go on forever. Bad idea. No one wants to be in the claims business forever. There's a beginning and an end. And finally, maybe the most important skeletal question, which PG&E is now trying to confront in California. Do you have enough money? How are you going to factor in liquidity, financial liquidity, and available resources in order to settle? Is it a settlement with an upfront payment, like BP has all the money in the world? They just said settle the cases and don't worry about a thing. We've got the money. Or is it money over time in installments? Is it tied to ongoing business performance? There are a lot of ways to come up with the necessary cash that you're going to need to resolve these cases. I mean, I must say, in every case I've worked on, money really hasn't been an issue, which is a nice thing to have. No caps in BP or 9/11. GM, no cap, whatever it takes, we want to get rid of the cases. Well, that's very, very helpful. Very helpful. In Volkswagen, I mean, part of Volkswagen's owned by the German government. I mean, it was never really an issue. Well, that's very, very good news when you're a special master or trying to settle, and you know that if the settlement is fair and reasonable, the funds are there. So those are all sort of skeletal issues before you even talk about the substantive dispute. But those issues loom very, very large, I suspect. In any discussion today where there's going to be interaction among these various issues concerning the 4 examples that David mentioned and other examples that I've mentioned as well. Then you get today to sort of the menu list of substantive issues. I don't care what the settlement is. I don't care whether it's environmental, health, business interruption, economic loss. You're going to get to a half dozen critical checklist issues that you're going to have to deal with today one way or another. One, who's eligible? Who's actually eligible to participate in the settlement? That is a huge issue. As I said, one reason the 9/11 fund is out of money today is the eligibility criteria went way beyond, presumptively, anything Congress ever anticipated. And that's why it's not only first responders that are getting paid for their health injuries, it's citizens in the neighborhood. It's people that lived on the highway going out to Fresh Kills landfill where they say the trucks drove by and caused asbestos and stuff and now I'm sick. And there are presumptions that were created concerning medical conditions. I'm not even taking a position on the wisdom of it. I'm just saying, is anybody surprised that they're out of money now? Nobody should be surprised at all. So eligibility is a huge issue. Mr. Feinberg, you're doing the BP case. I own a hotel right on the beach in Pensacola. The oil never really got to Pensacola. But everybody thought it was coming, and I lost 71% of my guests that were going to stay at the hotel. All right, we'll take care of that. Mr. Feinberg, I just heard what you just said. I own a hotel 10 miles from the beach. And I lost 71% of the clientele because 10 miles may seem to you a long way, but actually there's a golf course here, families come, some play golf, some go to the beach. I want the same deal. No, you're geographically 10 miles inland. You're not right on the beach. There's got to be different rules concerning eligibility. Different rules. Mr. Feinberg, I live in Stockholm. I make rope that I sell to fishermen in the Gulf, a special rope. I don't know anything about proximate cause, but my rope sales are down 9% because the fishermen can't fish, and even though I'm in Stockholm, and there you are. Am I eligible? Mr. Feinberg, I own a crab house a half a mile from your home in Bethesda, Maryland. Every day we get crabs from the Gulf. They come up, shipped. The Bethesda Crab House. I've lost a fortune because there's no crabs coming out of the Gulf now, and I can't mitigate. They only want New Orleans crabs, and now I'm stuck, and here's my claim. Well, have you mitigated by getting shrimp from Maryland or crabs? I mean, Maryland crabs? No, they only want, there you are. Who's eligible to participate in the settlement? And even after you determine eligibility, what's the methodology you're going to use to calculate the settlement value of the claim? Is it tort? That's the 9/11 fund. They said right in the statute, use tort law. Easier said than done, but they said use tort law, which we did. Is it strict liability? Is it comparative negligence? Is it a flat amount? You know, one very creative way we get rid of a lot of claims in these examples is by telling somebody, look, you can go through a 12-page claim form, fill it out, show us your damage, corroborate, attach your documents, or we'll give you $10,000 just to fill out a 2-page form. You don't have to go to all that trouble. Now, you may give up a lot more money if you think you can corroborate it, or we want to clear out 71% of the cases by offering a flat amount. If you fill out a basic 2-page form, it's a summary, and we'll settle the cases. I mean, there are a lot of different ways to develop a methodology for calculating the value of the settlement. 3, proof. What proof do you need to attach to your claim to show that you proved and corroborated your claim? Now, you can have all the presumptions in the world to help a claimant. You still have this requirement, don't you? At the end of the day, how do I know, as the settlement master, that your claim is legit? I'm not talking about fraud. We're not even suggesting that. I'm talking about valuing your claim. You may be eligible, but prove your damage. Now, that might mean tax returns, which few people have, especially in the Gulf, or there may be some other corroboration, but there's got to be some proof requirement to help value the aggregate of settlement and determine the individual claim. Next, what about the release? Now, you realize that in 9/11, the Deepwater Horizon BP oil spill, the General Motors ignition switch program, you take the money that's being offered in settlement and you waive your right to litigate. You waive your right. Volkswagen, Chrysler, you waive your right to litigate. Versus, Ricky mentions the Boston Marathon, or the Virginia Tech shootings, or the Aurora, Colorado Dark Night shootings, or the Sandy Hook Elementary School shootings, or the Pulse nightclub terrorist attack in Orlando, Florida, or the Harvest concert in Las Vegas, 50 people, 60 people killed. No release there. That's all gift money. That's money donated by private individuals and companies all over the United States. Give these people, it's terrible what we saw on cable news. We send in our checks. In the Boston Marathon, in 60 days, thanks mainly to Mayor Menino getting on a soapbox, $61 million came in from 100,000 people all over the country. 61 million. That's no release. That's not an alternative to the tort system. That's not an alternative to a legal process. That's 501c3 donated money. Everybody gets the same, flat amount for death. No complications there on methodology. And finally, due process. I mean, you're going to give people an opportunity to be heard. In 9/11, that was the key to the success of the program. Anybody who voluntarily wanted to come and see me could come and see me. You don't have to. People, human nature, people grieve in private. A lot of people grieve in private. They don't want to light candles down at the World Trade Center. They want to be left alone. Other people want to come and talk confidentially. Fine. But how do you build into your settlement a process of individually tailored conference or hearing that undercuts the argument of many that it's just assembly line justice, you see? And I find that due process is a very serious factor here in considering the overall strength of the program. So that's sort of an opening. I mean, something for everybody to think about going forward. Now, there are a couple of things David or Ricky said that I must say bear repeating. In all of the programs that I've ever been involved with, liability is irrelevant. No one's asked me to determine whether or not the company or the entity is liable. That's a judicial concept. That has nothing to do with my effort at getting compensation to victims. Right now, I'm trying to settle about 2,500 priest sexual abuse cases in New York, Pennsylvania, and New Jersey. the liability of the church is irrelevant to me. Posting the name of culpable priests is not on my watch. My watch is pay the victims. That's my job in all of these cases. Do I have the money, the resources, the design, and the plan to pay the claims? And if the government's involved, if I have John Cruden at the table and David Nachman at the table, it's going to get done. But who represents the government and what's their agenda, that is, that can make settlement difficult. And I don't really see how you can think about this today without factoring in those cases where the government's involved, where it's purely a private settlement like BP really was, or 9/11 really was. Government never, ever to this day has apologized for 9/11, never will. That money is not reparations, believe me. That money I paid in 9/11 is just goodwill from the people of the United States. Government will never apologize for wrongdoing or negligence in 9/11. I'm not sure they should, but they never will. So those are sort of, you can see why it's so much easier to do it in the morning. Before everybody starts throwing in their 2 cents and throwing curveballs. Because at the end of the day, you have to change your whole talk in light of, And you have to sit here all day. That's the other thing. You don't want to miss something. So I'm glad. I want to thank David. I wish I could stay. I want to thank David, really, and Ricky for inviting me to at least put out some issues that I think will come back during the day. And if you have a particular question during the day, you can certainly email me, or even better, just ask John Cruden how I would answer it. And he has my proxy, as does David Nachman, if and when David manages to get here. So I want to thank you all for what appears to be really a very, very timely conference. Thanks again.
Thank you so much.
Hope that was helpful.